Hello, and welcome to JD Advising's California Bar Exam Essay Guide. The goal of this guide is to help you find an effective and efficient approach to the California Bar Exam essays right from the very beginning. This guide will help you feel confident on test day so that you can conquer the essay portion of the California Bar Exam. If you have any questions about this or other resources we offer for the California Bar Exam, please don't hesitate to contact us. Some of our other resources include a California Bar Exam prep course, private tutoring, essay feedback, and one-sheets. If you reach out to us, we'd be happy to speak with you about the resources that can best help you prepare for the California Bar Exam. We hope you enjoy this guide and good luck on the exam. Criminal law and procedure is tested somewhat frequently, about once each year. It is somewhat predictable in how it is tested, and we see some of the same issues come up again and again. In recent administrations, questions testing this subject have tested both criminal law and criminal procedure, but older exams tested one or the other. We have not seen criminal law or procedure crossed over with any other subjects since 2008, but it is conceivable that this subject could be crossed over with something like evidence or professional responsibility. California has not tested California-specific criminal laws, so you can apply the same general law that you learned for the multiple choice questions to the criminal law and criminal procedure essays. Let's talk about some of the highly tested issues in this subject. In criminal law, some of the issues we've seen come up multiple times include homicide, theft crimes, and inchoate crimes. In criminal procedure, we consistently see California test one of two things, either Fourth Amendment search and seizure or Fifth Amendment Miranda rights. Although a few other issues have come up from time to time, because these two issues are tested so frequently, it is important that you know them well and that you know how to address them on a California essay. The first issue in criminal law that we're going to discuss is homicide. When this is an issue, you often have to identify the various potential degrees of homicide that could apply to the facts and discuss each one. The different types of homicide include first-degree murder, second-degree murder, felony murder, voluntary manslaughter, and involuntary manslaughter. Murder requires malice aforethought. For first-degree murder, that means there must be premeditation and deliberation. In other words, the defendant must have thought about committing the crime and then made a decision to commit the crime. For second-degree murder, malice aforethought can be satisfied if the defendant acted with intent to cause grievous bodily harm and the victim ends up dying, or if the defendant acted with extreme recklessness regarding homicidal risk and someone dies, or if the defendant has intent to kill but no premeditation or deliberation. Manslaughter is generally a less serious offense than murder. Voluntary manslaughter is an intentional killing of a human being, but without malice aforethought, that is committed in the heat of passion due to adequate provocation. The classic example of voluntary manslaughter is a defendant who finds his or her spouse cheating, and the defendant immediately shoots and kills the cheating spouse. The defendant was provoked by the cheating and was in the heat of passion, evidenced by the fact that he immediately pulled out a gun and shot the victim while he was still enraged by this conduct. Thus, the defendant would be guilty of voluntary manslaughter. Involuntary manslaughter occurs when either a defendant kills another human being due to recklessness or gross negligence, or the defendant kills another human being during the commission of a felony that does not qualify for felony murder. An example of involuntary manslaughter is if a parent has a sick child who the parent consciously chooses not to take to the doctor, and then the child ends up dying. That parent would be guilty of involuntary manslaughter in that instance. The next common issue in criminal law is theft crimes. Sometimes an essay question will identify a particular theft crime and ask you to identify the elements and discuss whether the defendant can be guilty of that crime. And then other times, the question will ask what crime or crimes the defendant can be convicted of, and you should discuss all of the possible options. The theft crimes that are tested most often on the bar exam include larceny, robbery, burglary, and receiving stolen goods. It's important that you know the elements of each precisely so that you can discuss them in detail and can also differentiate between the different theft crimes. First is larceny. Larceny is the trespassory taking and carrying away the personal property of another with the intent to permanently deprive them thereof. For each of those elements, you should essentially have a mini IRAC, identifying the element, stating what it means, analyzing the facts that go with that element, and then reaching a conclusion as to whether that element is met. So the first element is trespassory. This essentially means that the item was taken without permission. Next is taking. There must be an actual taking of the item. Carrying away requires that the object be moved, even if only slightly. It must be personal property, and it has to be someone else's. Finally, the defendant's intent must be to deprive the other person of their property. So if I take my friend's umbrella thinking it's mine, my intent is not to deprive my friend of her umbrella. But if I see my friend's umbrella and I decide that I want it and I'm going to take it for myself, then my intent is to deprive my friend of her umbrella. Where applicable, you would do the same thing for the other theft crimes. Identify the elements, explain what the elements mean, discuss the facts, and decide whether that element is met. So robbery is a larceny, which we just discussed, where the property is taken from another's person or presence by force or threat of force. Burglary is the breaking and entering of the dwelling of another at night with the intent to commit a felony once inside. You can use subheadings to identify the various elements, and be sure to be as detailed as possible in your discussion of each element, contemplating arguments for each side before you conclude as to whether or not that element is met. One of the other highly tested issues in criminal law is inchoate crimes. Inchoate crimes are applicable when the defendant does not achieve his desired criminal purpose, but has still done something wrong. They include attempt, solicitation, and conspiracy. When these crimes are tested, you may have to discuss multiple potential crimes that a defendant could be convicted of, or you may have to only discuss one particular inchoate crime that is clear from the facts. Just be sure to read the question carefully. Turning to the highly tested criminal procedure issues, we have Fourth Amendment search and seizure and Fifth Amendment Miranda rights. Criminal procedure has actually been tested more often than criminal law in recent administrations, and we keep seeing these two topics come up again and again. So it is really important that you know these two topics extremely well. When the Fourth Amendment is tested, it's a good idea to start your discussion of this issue with a general overview of the Fourth Amendment. So you would begin by noting that the Fourth Amendment applies to searches and seizures conducted by government agents in areas where the person complaining has a reasonable expectation of privacy. You may need to discuss whether the questioned conduct constitutes a search or seizure. You might also have to discuss whether the person conducting the search or seizure is a government agent. Usually in these questions, it's a police officer who is pretty clearly a government agent. And you often need to discuss where a person has a reasonable expectation of privacy. Some examples of individuals who have a right to privacy include an owner or a resident of the premises searched, or an overnight guest in the place being searched. On the other hand, a person who uses a residence for business only, like a drug house, has no reasonable expectation of privacy in the premises. Nor does an individual have an expectation of privacy if he stores an item in an area where he has no expectation of privacy, such as a person who stores drugs in his girlfriend's purse. He has no expectation of privacy in her purse. Nor do passengers of a car have an expectation of privacy in the car. So if a person has no reasonable expectation of privacy, that person is not entitled to any Fourth Amendment protections if the police conduct a search or a seizure of the area. Once you've discussed whether the Fourth Amendment applies, next discuss whether the Fourth Amendment has been satisfied. The Fourth Amendment can be satisfied by a valid warrant that is validly executed, or it could be satisfied if an exception to the warrant requirement applies. Generally, there must be probable cause in order for the government agent to validly conduct the search or seizure. One sub-issue of the Fourth Amendment doctrine that we've seen come up is for Terry stops and Terry frisks. A Terry stop is a brief seizure of a suspect to investigate criminal activity. A Terry frisk is a pat-down of the suspect's body. Because these searches are only minimally invasive, less suspicion is required than is generally required for a normal search or seizure. Instead of probable cause, an officer only needs reasonable suspicion that criminal activity is afoot to conduct a Terry stop. For a Terry frisk, the officer only needs a reasonable belief that the person is armed and dangerous. Be sure to memorize these lower standards for these minimally invasive searches and seizures that an officer is permitted to conduct without a warrant. The other issue that we see tested a lot in criminal procedure is Fifth Amendment Miranda rights. The Fifth Amendment Miranda rights provide a suspect with the right to remain silent and the right to an attorney whenever the suspect is subject to custodial interrogation. To begin your discussion of a Fifth Amendment issue, first ask whether the suspect is in custody. To determine whether a person is in custody, ask yourself whether a reasonable person would feel free to leave under similar circumstances. Consider things like the duration of the questioning and the location. Someone who's being questioned at their own house likely feels more free to walk away than someone who's brought into the police station and is being questioned in an interrogation room. The next question in the Fifth Amendment analysis is whether the person is being interrogated. Interrogation is questioning initiated by law enforcement or its functional equivalent. Asking about background information is not usually considered interrogation, but making a statement that is designed to elicit an incriminating statement from the suspect would likely be considered interrogation. So, for example, if an officer said, "Your accomplice already admitted to committing the crime," this is likely interrogation, even though it's not in the form of a question, because it's meant to elicit a response from that suspect. Once you determine that the Fifth Amendment applies because the suspect is subject to custodial interrogation, next ask whether the defendant has invoked his rights or waived them. Generally, in order to invoke, the defendant must make an explicit, unambiguous, and unequivocal invocation. A waiver, on the other hand, must be knowing, intelligent, and voluntary. The next tip for criminal law and procedure essays is to make sure you have the important rules and legal terms memorized. Because some of the same issues are tested over and over on criminal law and criminal procedure, it seems like the examiners are expecting fairly precise rule statements. So having the exact language memorized will help you maximize your points. Additionally, you will want to know some of the key case names that we already mentioned, like Miranda versus Arizona, which gave rise to the Miranda rights, or Terry versus Ohio, which gave rise to the Terry stop and Terry frisk doctrine. Being able to refer to these as Miranda rights or Terry stops will definitely be helpful. Finally, make sure you use the keywords and phrases when discussing the various doctrines. For instance, when you discuss the Fifth Amendment, it is important that you mention that the rights attach upon custodial interrogation. You should also be able to identify and discuss the difference between probable cause and reasonable suspicion and when each of those different standards applies. Finally, it is extremely important to practice criminal law and procedure essays. Because certain topics are tested over and over, completing practice essays is the best way to ensure that you're prepared to handle those issues should they appear on your exam. We recommend that you look at the criminal law and criminal procedure essays from October 2020, July 2019, February 2018, February 2017, and July 2015.